basics of copyright law, especially when it comes, to your songs and, and protecting them and feeling like, you got your shit together. Well, I'm just going to go ahead and give you a quick overview of copyright basics, and this is going to be part 2. Part 1's also available if you want to check it out. So pretty much here's what we're going to be covering in class today. We're going to be talking about joint works, duration, and the copyright notice, and also copyright registration. So first, it's important to understand what's called a joint work. Or a collaboration, also known as a collab, right? So what are joint works? So real quick, last week we talked about what's called an exclusive bundle of right under the United States Copyright Law, Section 106. So that is when you compose a song, you immediately get rights. When you compose an original song, you immediately get the rights to that song. And that's the rights to reproduce, distribute, make a derivative work, and also to publicly perform. But what happens when there's 2 people involved in that process, right? Then 2 people are going to have these equal rights. But obviously, when there's more people that are involved, it's going to get more and more complicated, right? So let's go ahead and talk about this. What is a joint work? When 2 or more people come together and they share either musically, lyrically, or some hook or tangible beat or groove, a joint work is formed, okay? Now, one thing that's very, very important to understand is that means that all of the writers that were involved in doing that jointly own the composition. Okay. And I also need to make it very, very clear that they jointly own the entire composition. It's not like I own the lyrics and you own the music. No, we own our share equally of the entire thing. That means I own the lyrics too, even though I just did the music, and you own the music too, even though you just did the lyrics. And a really good metaphor and the way to think about this is if I were to take an egg and crack that egg, and there's yellow and white in the pan. As soon as we mix that together and that becomes scrambled eggs, you can no longer separate that, obviously, right? So we are talking about the fact that the 2 parts are inseparable, okay? So that's very, very important to understand. Another really, really important thing to understand is the ownership of the joint work. In the ownership of a joint work, you have to be clear that we're talking about an equal percentage by default. So if there's 2 people, 50%, 50%. 3 people, 33 and a third, 33 and a third, 33 and a third. 4 people, 25%, 25%, 25%, 25%. 5 people, 20. 6 people, 16.2 thirds. 8 people, 12.5, etc. It's equal no matter what part or contribution you made. So even if I make a little bit of a lyrical contribution to a song, I own 50% of the entire song. Now, in a band situation, most people would be cool with that because it's like one for all for one. But generally speaking, you should have a discussion about how the songs are going to be divided, particularly if everyone isn't writing equally, okay? So again, in a band situation, that is usually the way most people do it, simply because they want everyone to feel like they're a part, But if you're just like writing with casual collaborators or partners or something, that might be totally uncool, especially if you have most of the song idea down, and then you kind of get like a little input from somebody else, and then they feel that they should own half of the song, So you have to decide that, okay? One of the ways to decide that is through what's called a split sheet, which we talked about last week. And a split sheet basically is a sheet that has the splits of the songs on there and other important information, so that if you ever got into an argument down the line, you have this written agreement that says, hey, we said I'd get 80 and you get 20. Okay, there's some apps that exist out there for split sheets, but personally, I don't know if these apps are going to be around 20 years from now, So, and the life of a song goes on for a long time, so you might want to think about that, okay? All right, another thing that we have to talk about is control of those joint works. So another issue that's really important is that when you own something with somebody, they are entitled to issue as many non-exclusive licenses as they want, as long as they pay you your prospective shares and they acknowledge that you exist. But I can do that too. But what happens if we have a disagreement about how the song could be used? You might want to put it in a porn. I don't want to. You might want to put it in a political rally. I don't want to. You might want to put it with some goofy commercial. I don't want to. So in the split sheet, we should also have an agreement about how the song will be used. And typically when people own a song together, they have an agreement that says something like the song cannot be used unless we all agree and sign off on it. Or in some cases, when a singer-songwriter is writing, maybe working with a producer that helped write out the song, they might say something like, I am using this song on my record first, so no one could use it on their record first, only I can. So that's an important topic to think about, okay? All right, moving on to the next thing. You have this wonderful joint works, and how long do you get to keep this baby for, right? So just keeping things simple and keeping things with the most current copyright law. When you write a song, you get it for your full life plus another 70 years. So that basically means when you pass on, you will have a will and you'll write the song over to maybe your family and they will have it for another 70 years, okay? What happens if you write a song with a co-partner? Then it's the life of the last living author plus 7 years. So if two people write a song and person A dies, the 70-year clock does not kick in yet until the second person dies, okay? What else do we need to talk about? There's something called public domain. I beg your pardon. There's something called all right, well, I think that's good enough for now, copyright term. Let's talk about the public domain. So what happens when the song falls into what's called the public domain? That means after the copyright term expires. That basically means that anybody can use that song free of licensing fees. But here's one thing that's very, very important. First, you have to make sure that a song is in public domain. And then you also have to make sure that it's in public domain in other countries too. Because if the song gets published in another country that has maybe a little bit of a longer copyright term than us, then you could find yourself getting in big trouble. So let's just say I wanted to cover a Christmas song that's in the public domain in the US, but maybe somewhere else where there's a longer copyright term, let's just say in Mexico, and that song gets published in Mexico, then I'm in trouble. So you always have to do a really, really good search, okay? All right, another thing that we're also going to talk about too is what's called reversion of copyright. So reversion of copyright doesn't have anything to do with the copyright term. It's a contractual term in publishing agreements, but it does have to do with how long somebody owns something. And that's why I'm going to bring it up right now. When you sign a publishing agreement, you're essentially signing over your rights to a music publisher. And that publisher sometimes will want the rights for LOC, the life of copyright. You have to be careful about that, obviously, right? And most people will ask what's called for a reversion of copyright. That means that the copyrights will revert back to you at some point in the agreement, or after the agreement, rather. And it's typically maybe 10 years after the term of the agreement, but it also requires that all advances have been recouped, and there's other issues that are involved in that too that are a little bit more complicated. But just generally speaking, we'll get to that later. So you want to make sure that when you do a publishing agreement, get reversion of copyright. Now, what happens if you screw up and you don't? Thankfully, there's something in the United States called 35-year right of termination, and you can get your copyrights back, but that's 35 years later, right? Now, some hits last longer than 35 years. So I've known people that have had hits, signed bad publishing agreements, and then 35 years later got their rights back. But keep in mind, this is good, but keep in mind the disadvantages are that it's only in the US, so you'd only get your rights back for the US, and you'd only get the rights to new licenses. In other words, the publisher will still be able to earn monies from the songs from the previous deals that they did. All right, let's see what else. Copyright registration. Okay, so now let's talk about protecting these things, right? So you already know that you have an exclusive bundle of rights under Section 106 of the Copyright Act, right? You know that, which is pretty awesome, right? You get the exclusive bundle of rights. But now, when you register your copyrights, you get 3 more very, very important rights. So what is registration? Registration is the process of letting the copyright notice, making a public notice, rather, to the Copyright Office of Washington, D.C. that you are the author and owner of a song. So you do that by filling out forms, paying a fee, and sending it into the Copyright Office along with a deposit copy and information about the song. And the best time to do this, really, is right upon publication or shortly after. Okay, there's a couple reasons for this. Number one, copyright registration can be expensive if you write a lot of songs, of course. And when you first write songs early on, the songs might not be worth anything. I wouldn't steal some of the songs that I first wrote, right? So essentially, you want to get your songs registered because you get three important rights. You get the rebutable presumption of ownership as long as you register within 5 years of publication. That means that anybody can challenge you, but the Copyright Office will think it's yours. It will be the other person has the burden of proof. Number two, you get the rights to sue in a court of law. You cannot sue until you register. And number three, you get what's called actual or statutory damages. That basically means you get the actual amount that you suffered, or sometimes because that's difficult to prove, you'll get what's called statutory damages. The statutory damages are basically a judge can hand down an infringement charge of anywhere from $750,000 to $150,000 per case of infringement. Obviously you want to have statutory damages. In fact, most lawyers won't even take a case unless you have statutory damages. But here's what's really, really important. You need to make sure that you register your copyright before somebody rips you off. Okay, so since you don't know if someone's going to rip you off, you obviously want to register your copyrights as soon as you get them out there and you publish them, or shortly before. Okay, what else should we talk about? Tips to save money. Registering an individual song could be $45. Registering it with a co-partner could be $65. But there's something called a group registration, a group of unpublished works. That means you can group up to 10 songs of works that are unpublished, not released yet, and you do it for one price of $85. Or you can do up to 20 songs of songs on an album, published songs on an album. So when you release songs, if you want to gather up all of the songs that you've published, as long as they're on the same record, you can do it for one price. And I believe that price is $65. So the Copyright Office is giving you some incentives to register groups together. Okay, what else? The copyright notice, like copyright C by Bobby Borg 2025. Do you need to write that? It's recommended to do it on visually perceptive works, like on album covers and album artwork and that type of thing, or like the liner notes where you're writing your lyrics and indicating all the different publishers. And this is true, especially after 1989, the United States entered into something called the Berne Convention, which basically says you no longer have to include the copyright notice, but it's recommended still, of course, to still do that. All right, so this is just kind of like a little bit of a basic rundown of some of the things that I'm going to be talking about today. That's pretty much it. My name is Bobby Borg, helping musicians turn their art into a more successful business. If you guys have any questions, please feel free to put them in underneath, in the area below, and I will get to them later. It's kind of hard for me to do right now. I'm sitting out in a field, and and it's kind of hard to do three things at once. So I will get to those questions later, okay? And also, tons more videos on my channel, youtube.com/Bobby Borg. So check those out too. My name is Bobby Borg, helping musicians turn their art into a more successful business. Peace, love, and later, guys. Take care. Bye-bye.